Hello everybody, and thank you for joining me on today's episode of the Activist Lawyer podcast. I am delighted today to be joined by Daniel Machover, who is one of the UK's leading solicitors in his field and expert at vindicating the rights of people who have suffered at the hands of the state in inquest and public inquiry work and in representing individuals and organisations in complex civil litigation cases. Daniel works with Hickman and Rose solicitors, and he joins me from London. And I mean, we really wouldn't have the time to go into all of Daniel's pioneering human rights work. He has worked on so many high-profile cases, including the Grenfell Tower Inquiry, Azelle Rodney Inquiry, and many, many more. I was also interested in getting Daniel's opinion and perspective on what's been happening at an international level in terms of the ICJ and the ICC in the cases brought against Israel, particularly the ICC and the arrest warrants, because he has some interesting experience in issuing arrest warrants himself that he goes into, which is really, really fantastic. He'll also take you through why he became a lawyer, again, a fascinating story, and has some sterling advice for any of our listeners who are interested in following his work. So I really appreciate his time. He's a very busy man, and I hope you really enjoy today's episode. Please remember to review and share with your colleagues and friends. Thank you. Hello, Daniel. Thank you so much for joining me today. It's great to have you joining us from London, I'm guessing?
I am, yes, and thank you for having me.
Not at all. Well, before we get into some of your work, which I'm really interested in, and I've been following a lot of your work and some of your recent interviews for some time now, I'd like to go back in time a little bit and discuss your journey into law and what maybe inspired you to enter the legal profession as a solicitor.
Yes, I think it does relate to my family history to some extent. So my parents left Israel as anti-Zionist Israelis after the Six-Day War when I was quite young. They had a very strong sense of the injustices that Israeli society was inflicting on the Palestinians and the history which had brought matters to that point. And they left at the time thinking they were coming back. It was just a temporary respite because they'd been outspoken against the occupation from the early days of it in 1967 and had received death threats and found they didn't want to bring up children in that climate. So my sister and I and they came to England, and I've been aware of that background on visits. We used to visit Israel every summer throughout the 1970s, and my mother was taken off for a strip search when we were just, my sister and I were with her on one occasion. And that finding out what had happened, although I wasn't present, but just the idea of it and that history built in me a sense of justice and injustice and what people needed to do and should do, and supporting those who had suffered injustice and how that could be done. So that sort of was bubbling away. Sure. And I was aware that I had relatives who were lawyers, although I didn't have immediate relatives, and it was interested in that side of things. And I think then just from a very early age, I can't identify it exactly. I was interested in studying law. I actually regret doing a law degree because I was just in a hurry to become a qualified lawyer. Yeah. But I think, anyone who comes to me now and says, I want to be a lawyer, etc., I would say, unless for economic reasons or for reasons that you're in such a hurry, I would take another degree. But anyway, that's by the by. Wow. But I was in a hurry. And I would say easily from the age of 14 or 15, I just wanted to be a lawyer. I wanted to study law. And as I mentioned earlier, I think that came from some of that. And growing up in London in a period of, we're now witnessing these terrible outflow of racist violence. And that was very much the climate of the 1970s, and being involved as a teenager in anti-fascist movements and living in the part of London I live in, very near, and all my friends lived in the Notting Hill Gate, Ladbroke Grove area. I lived in slightly further out, but that was a climate in which, people were witnessing injustice, and I was aware and became aware of legal work being done on those kind of issues. So I think that's basically it.
Wow, and it, as you say, I mean, it's hard to comprehend that we're back there in many ways and witnessing what's happening at the moment. And also the attacks on lawyers as well seems to have increased drastically too. So it's a very, tense time at the moment. And just your casework and the type of work that you do, I know that it's very much focused on inquests, and the firm that you work with, Hickman and Rose Solicitors, you've been really leading the way on many of the high profile inquests that a lot of our listeners will be familiar with. What made you get into that type of work, the inquest, the civil litigation, and I suppose the victims of state crimes as well? I know we had barristers and cases on who were involved in Sean Rigg and Azelle Rodney, some of the cases that you've also been working on. Is that the type of work that you started off doing, and what led you into that?
No. I mean, I'll try and keep it relatively short. I started off as a lawyer working for tenants, a housing lawyer. So I did lots of disrepair cases. I did homelessness cases. So I qualified in the late 1980s and went to a high street law firm, and I was doing mainly housing. My first civil trial was an eviction, and a lawful eviction case at Wilton County Court with an excellent housing barrister. And so that's the work I was doing initially. And then I stopped my practice briefly and did a law postgraduate, wanting to move into international law and to do the kind of cases I didn't actually really start doing until 10 years later, and we'll come back to that. Mm-hmm. But that was what I had in mind then, rather than becoming the lawyer that I then became. And that all changed when I worked at North Kensington Law Centre. So at North Kensington Law Centre, I was a housing solicitor for a few years, and then we were doing police actions. But in law centres, you quickly become, and I was the senior solicitor in the law centre, even though I was relatively young still in my, I guess I was in my late 20s still. And I started supervising inquests and police actions, bizarrely, because there was a more junior solicitor who was doing that work, who had done a bit of that work in her training. So that's actually how I got started. So I was doing judicial reviews of homelessness decisions and disrepair cases, big disrepair cases in Kensington, Chelsea, and very near. I had clients in Grenfell Tower in that period, which many years later became an important experience. Wow. But so that was it. And in parallel with that, just to sort of complete the circle as to how I then moved in the mid-90s into a firm with Sadiq Khan, now Mayor of London, who was a very, very good police actions lawyer in the mid-90s. But the big change for me was, alongside my law centre work, I started working with Liberty as the legal team at Liberty. I was a volunteer, but I also was seconded by the law centre, having done a bit of police action supervision for a period because they needed an extra pair of hands. For about 6 months, I worked in Liberty. That was in 1994. But earlier in that period, I did what led me into this work. Really, is I co-authored Liberty's third-party intervention, the first one they'd ever done at the European Court of Human Rights into the case of McCann versus the United Kingdom, which is still a leading case on Article 2, the right to life. So that's the case, the Gibraltar 3 case. That's right. So that was it, really. So from the mid-90s onwards and until now, I've specialised in police action, inquest, death in custody work, and we'll get into that. Yeah. But that's how I got there from having started as a housing lawyer.
Fascinating. And one case, I mean, it struck me to read about the Kelso Cochrane case that has been covered quite recently in the media, noted as Britain's first racist murder. I'm wondering what the significance of recent developments are in relating to this case. It dates back to the 1950s in London when the event occurred. You might tell us a little bit about that.
Yeah. No, of course. So in a way, again, it's full circle. I have to say, I'm embarrassed to say that when I worked at North Kensington Law Centre, he was murdered literally meters away. Kensington Law Centre was in the 1990s. I wasn't aware of the history of that murder, but somebody I worked with at the law centre in that period became a kind of leading campaigner about bringing forward and bringing into modern consciousness the importance of that murder in the local history and in fact in national history. So that murder in May of 1950 followed a period of racist attacks and the Notting Hill riots, as they were called, of 1958. And they were a very significant social event. They had led in the 1960s to really important legislation that lives with us now, criminalising racist attacks, criminalising racist incitement. None of those were offences, but a social movement that grew around anti-racism, and including the Notting Hill Carnival, by the way. All of that originates in social movements seeking justice for what black people in West London and across the country were experiencing at the hands of fascists. And is the kind of, it's really the historical kernel of anti-racist movements across the UK, with others. I don't want to overplay it, but that it really is an important history. And what happened is in this period, those racist incidents never led to any fatalities in 1958. There were really nasty, horrible, appalling incidents, but no one had lost their life. But in May 1959, when Kelso was killed, the police immediately sought to downplay the potential racism, and the family were misled, we now know, very significantly, as were the public. There was never anyone charged or prosecuted with his murder, and the family came to me a couple of years ago saying, look, we've tried to get hold of the files that are held in the National Archives about this investigation, because there was a book written by a journalist called Mark Oldham who'd gone through it all with what was available, and it's clear that the key suspects, who were well known to be, the names have been going around the Notting Hill Gate area for years and years, and they died. And yet the files were being secretly held, and weren't going to be released until long after the remaining members of his family were deceased. 2054 was the date.
Oh my gosh.
So we did a massive FOI request with a huge amount of evidence from journalists and experts in this whole area of history, showing the public interest in releasing the files, and they were no longer the crime exemption from release, which is that release of evidence might prevent a future prosecution. So we now have access to the files, and just the headline shocker is that the key suspect, a guy called Bregan, who's since died, of course, said when he was arrested for a appalling set of racist attacks in 1957, so 2 years before the murder, he was arrested, and he said, if I go down for this, and he used racist language, I'm going to kill the first black man I see. He was one of the key suspects. They knew that about him, yet they were saying there was no chance this was a racist attack. And he was one of the killers of Kelso Cochrane. I'm absolutely clear about that for the evidence that we've seen and that the police saw at the time. Was within a week of him being released from that sentence.
Incredible, isn't it?
So, the family deserved so much more, but it reveals lots. And I've had a solicitor who was qualified in the very early 1970s who's looked at that evidence, and it's absolutely clear. Just as one clear example, they didn't hold a single identity parade. And I can tell you that at least five people saw the key suspect on that night. You know, they were able to piece together that evening. And again, another vignette, about 150 meters away, maybe 200 meters away from where he was murdered, another racist incident happened that took a lot of police diversion, because there were two or three parties going on in that evening, which that had gone out onto the streets and where there'd been encounters with youths encountering each other, and there's a really nasty racist incident that occurred, and they weren't clear about the connection between that incident and Kelso's murder, because they happened not long after each other and very close to each other in proximity. So there was a period of some confusion as to whether they were connected. I think the perspective of the family today on this is that they want, from the long ago history of these events, for society to do better, for the police to do better, and to learn from this. And I think the learning that can still be had from this is just very fundamental. It's about addressing prejudice and ignorance and the root causes of some of this violence. I mean, looking at the histories of these young men back in, as we know them from Notting Hill Gate, is just ignorance and prejudice. And you will see that later in their lives, as some of them moved on, and we know some of the histories of the young men that were at the party, who then became integrated, and the local population mixed. Notting Hill Gate is now a very mixed area, and it isn't the area where we saw some of the horrendous events out, in various parts of England and Wales, and including in parts of London. Yeah. But I think that there is a learning which is fundamentally about ignorance and prejudice, but also about not denying what's in front of you and addressing it, and then addressing the root causes. I think the disappointing aspect, I would say, was an excellent article going sort of sideways from this. I think it's by Maya Goodfellow in The Guardian just in the last few days, which says, well, we keep on hearing these people saying, including politicians, saying there are legitimate concerns. This family, that journalist, don't agree with that assumption on the part of too many people. There is not a legitimate concern. There's ignorance and prejudice and a misunderstanding of the history of Britain as a colony, of Britain as a beneficiary of mass and sometimes called for immigration, as we know, from the Windrush generation. So that's what needs to be addressed: inequalities in society and the reasons for them, and the benefits of having a society which draws in people from abroad, that strengthens us and enriches us in so many ways, and which we're lucky to have as a society. So it's these legitimate concerns are not really there, and they need to be fundamentally addressed. And unless you address them, then you will have prejudice and ignorance being built on those fundamental misunderstandings of what it is that drives inequality, and I mean social inequality and poverty. And that seems to be a rather basic necessity to learn from all this. Where ignorance gets you to small, the attacks on small boats. It's why there is such a driver for people to leave their homes. Nobody wants to leave their homeland and become a migrant in the way that we're talking about these people. These are not economic migrants. And even if they were, that's because who is it at the moment that is doing some of the carer work, some of the basic jobs? Basic is the wrong word. Some of the lowest paid work in carers or as NHS workers. Who is it? Who is it that's taking these jobs and fulfilling these? So some of the people that are coming from countries across the globe are some of the most caring people. They literally are carers who look after the most vulnerable, and yet we're turning on them. Why? Yeah. What's behind all of this? It's just prejudice and ignorance, all of which can be addressed if there's a will to do it, and that's what we need to do. So I've gone very sideways, but I think I know that's what the sentiment of my clients who are driven to get access to this. Yeah. They want to know what happened. They want everyone to learn from it, and they want there to be a deeper understanding so that these events can be addressed where they happen and in future avoided.
And it's fascinating. I mean, that case dates back to the 1950s, but it's so relevant today, as you say, in terms of the learning. And despite that being, a murder case, so much more has come out of it in terms of, as you say, kind of the ignorance and the structural racism that occurs. And of course, you've seen that throughout a lot of your work, particularly with, I'm thinking of Grenfell Tower as well. I mean, it all links together. And you quite rightly mentioned issues around immigration and migrants too. But it just seems so seismic at the moment. The problems that you can see why people lose hope. But as you say, if we have the will to press on, we can make change. But it's societal change that needs to happen. And I suppose just going back to your initial point when I asked you about getting into law, and you candidly discussed your family's background as well. You were the co-founder of Lawyers for Palestinian Human Rights, and I'm just wondering, I mean, that your advocacy and your commitment to justice for Palestinians has been part of your whole life, it would seem, since you were born. Why did you think at that time it was necessary to set up that organisation? And, I suppose what's behind your continued advocacy for the rights of Palestinians, which does, as I said, go back decades?
Yeah, well, obviously there's the history I've already touched on, but then really started at university. So I started at university just after the summer of 1982, which had been the Israel's invasion of Lebanon and the Sabra and Shatila massacres in the Palestinian refugee camps in the suburbs of Beirut, which were carried out by Christian phalangist fascists against Palestinians, sort of as part of the post-Lebanese civil war history, but overseen and in a conspiracy with the Israeli state. The then defense minister, Ariel Sharon, was very much involved in providing the military cover for that to happen. So in the wake of those events, I got involved immediately in student politics around Palestine, Israel, from the early 80s through to the mid 80s. And then as I became a lawyer, I saw, and I then I began to establish contacts partly through the undergraduate dissertation I did, which was on the seizure of state lands. So how Israel created its settlement policy in the West Bank. So I examined the law behind that, and I established and this is probably touching on that wider community that listens to your podcast, students. I became involved as a student with lawyers in the field because I went and did this dissertation. So I used the opportunity of doing that dissertation to reach out to senior lawyers already working in the field, and the people who set up one of the West Bank organizations, Al-Haq.
Yeah, brilliant.
I established contacts with them and with Israeli Jewish lawyers working, a guy called Avigdor Feldman, who's a really important Israeli lawyer working on human rights, and then friends and peers of my parents who were lawyers, who I didn't actually know as a child, but I began to network with them. So that was in the mid-80s. So by 1987, when the first Palestinian uprising, so this was civil disobedience, very different. People who haven't studied the history need to understand there was a huge period of civil disobedience by Palestinians in both the Gaza and the West Bank under occupation that started in the mid-80s, very much closer to non-violent resistance, involving no weapons at all, trying to resist occupation. That led in turn eventually to the Oslo Accords, which we'll go into separately. But as a lawyer, I felt it was necessary for us to coalesce as a group. So I, with other lawyers who were interested in these issues, co-founded Lawyers for Palestinian Human Rights during the beginning of this Palestinian uprising. And we started to lobby government to change its policies. We did some original research into things like the use of administrative detention, which is a massive problem still. So this is holding people in effect in internment, using British mandate powers in the West Bank that still exists. So the mandate authority, Britain passed emergency regulations which were part of the domestic law which the Israelis then used as a basis for holding people without trial. So that's where that came from.
I mean, you mentioned there that you examined Israel's settlement policies and you liaised with many experts on that back, in the 80s and 90s. I'm wondering what your opinion is on the ICJ advisory opinion, which came out recently on the occupied territories and Israelis' policies. Do you see it as a positive move, or is it another kind of, something that's quite... significant in the legal sense, but won't really make much difference on the ground?
No, look, it's difficult to apply a crystal ball even weeks after the ruling. But the ruling of the 19th of July, the advisory opinion of the ICJ, is a game changer in my view. And I think it will be viewed as that in 6, 9, 12 months from now. It should be.
Yeah.
And the reason is, so Palestinian lawyers and activists who I've worked with for years have been saying very much what the leading jurists of our era have now said. I mean, we must be clear. This ruling, the advisory opinion, there were various votes, but they're 14-1, 13-2, 12-3. But we're talking about, in the majority, an American judge, a German judge, an Australian judge. These are not, this is a global court in which some of the leading jurists of our generation, or of my generation, have ruled very important things to be the case, that this is now an illegal occupation. There's a slight dispute as to whether it was legal ab initio or has become illegal. Okay. But it doesn't really matter. As at 2024, and as I say, there are arguments going back to the late 1980s when I was working on this and before. But certainly now it's an illegal occupation. It must come to an end as soon as possible, or words to that effect. But then there are the consequences, and this is where you were touching on.
Yeah.
The operative parts of the advisory opinion, after they determine what various illegalities of Israel's conduct are, that the occupation is itself illegal and they're conducting various illegal activities specified in the advisory opinion. And then they go on to say there are positive duties of UN organs and who invited the advisory opinion, because it's a General Assembly request to the court, but also of third-party states. And there are two operative paragraphs. One of them is quite specific because it talks about not entering into treaty relations where the occupied territories may be affected. And in that paragraph, it's very much focused on not recognizing the illegality and not trading on the illegality specifically to do with the occupation. But the next paragraph is, in my view, key and wider, because what it in effect says to me, and I've said this elsewhere, is there is a positive duty to apply boycott, divestment and sanctions. And I interpret that, and I haven't yet heard a convincing argument the other way, because if they'd stopped at the paragraph above that I'm talking about, which was very specific about not recognizing the illegality and not doing certain things which directly relate to the occupation, but in the next paragraph, they talk about not doing anything which assists the fact of the ongoing illegality and taking positive steps in respect of the duty to Israel to end the occupation. Well, I don't think that paragraph was needed unless it was saying and meaning something wider. Yeah. So I interpret it as effectively requiring states to do an audit, basically, of everything they do, their diplomatic, economic, cultural relations with Israel. What is it we do, not specifically to do with the occupation, what is it we are doing now that's assisting the Israeli state? And I would say anything you're doing where you have someone conducting an ongoing illegal practice, just by treating them as an ordinary state, and doing day-to-day relations. You are assisting that from continuing. Until you put your foot down and say, no, stop, we're applying sanctions on you across the board, Israel's going to continue. It's not a question of micromanaging this particular product from the Israeli settlement and saying we won't import that. That is a duty. That's the earlier paragraph. You don't need the second set of duties on third-party states. Then they don't mean anything because you've already got the previous paragraph which deals with as I said, specifically not helping the particular acts that Israel's doing in the occupied territories. And one of them would be to make sure you don't import settlement products. But arguably, the paragraph below says you don't import anything. You stop economic relations with that power. So, of course, if it does have that application that I suggest it should have, and states then comply with it, that's a game changer. But even if we fall short of that, even if they did everything they should do in the previous paragraph, and states comply with that in a more narrow sense, we should see that Israel there's a cost to what it's doing. So that's how I'd answer that.
And I mean, that's a great answer and very clear. But I suppose even lawyers and non-lawyers alike looking on at the judgments that come out of the world courts recently in respect of Israel, that's the main question. Well, how does it apply? And I think a lot of people will say, well, they've lost faith in the law and in terms of international law in particular, international humanitarian law and the UN mechanisms, and you can't really blame them. But as you said, the law is there. So it's clear. And it's hard to be critical of the law if it does, there are two very strong paragraphs that you just set out. But why do we think in this case, and apartheid was mentioned as well by one of the judges too, which is highly significant in that matter. But is it a political decision, or why? Let's look at the UK, for example. Are they ignoring these judgments when they are so forthright in upholding the rule of law, but not in this instance?
Yeah, I mean, we've got a bizarre situation now, which is we've got a post-Second World War result which still had the colonial past of the major powers. We've got a kind of frozen situation which is after the Second World War, and we now have a much more post-colonial approach to the law. And it's fundamentally what we've got judges who are prepared to be modern and apply the law without fear or favour, and that's welcome, and that's not necessarily completely predictable, I have to say. If you look at some of these individual lawyers and the journey they have taken in getting to the point where the law is, as you said, clear. What we've got a problem with is enforcement, and the problem, one of the major bodies to implement this is the Security Council of the United Nations, where we have the veto-holding members frozen in a time of the end of the Second World War, where there had to be some trade-offs as to who the 5 veto-holding members of the Security Council. So it's like we have, and this happens in states from time to time. I've just been dealing with a particular state where there were very liberal judges still applying the law, but a totalitarian state not enforcing the law. And it's this difference between the law is caught up and is in the sense of understanding these issues which I've been talking about should have been the subject of legal rulings from the 80s, 90s onwards. Finally, in 2024, we have a form of justice or justice findings of justice, just findings, if you like, for Palestinians in this context. That's taken a huge battle. Didn't happen without a lot of battles all along the way for the whole period that I've touched on and before. But we have a problem with enforcement, with the state. So it's like a situation where we have a liberal judiciary and the law being stated clearly, but a totalitarian state, which has happened in individual states. So this isn't unique to international law. I just want to be clear. And nobody should be either rose-tinted about international law or misunderstand that this happens where you have in-power relations with the state that's got to enforce and apply the law, the bodies that are there to actually implement the law and make sure that illegality doesn't continue. in a tussle with those who state what the law is and whose job it is to state what the law is, but who are not being heard or having their judgments enforced.
Yeah.
So it's sadly not unique to international law, but we're living in a very disturbing period where that gap is getting wider and wider.
Yeah, it really is. And even, I suppose, separate to the historical case there on the occupied territories and Israel's policies, just touching briefly on the ICJ case brought by South Africa on the Genocide Convention. Similarly, and people aren't really aware of this, there's an obligation on a member state of the Genocide Convention to act promptly, even where there is a suspected case of genocide. Now, the decision there, which I know that case it'll take many years, I'm guessing, to resolve, I don't know, but plausible genocide was the finding that came out of that. And surely those words are so strong that, and even before those were, even at the investigation point, states should have been looking over their shoulder and saying, right, what should we do to act now? There doesn't seem to be anything. I know there are states who are joining in the convention, and they're joining South Africa, and they have already cut ties with Israel on the basis of that case. But the big runners like the UK, the US, are again really falling short of the basic obligations under the Genocide Convention. I know US aren't a party, but why is that? I mean, this is such a serious matter. And I mean, isn't that demonstrative of complicity, really?
Yeah, I'm afraid it is. And then, yes, the clue is in the words of the convention. It is called the Convention for the Prevention and Punishment of the Crime of Genocide. Prevention. It's there because everyone agreed at the end of the Second World War to come together and to seek to prevent. So there are positive duties to prevent. And you don't prevent something that's already happened. You prevent something that's a genuine risk of happening. And that threshold was passed when the ICJ issued its first ruling on this, after the hearings on the 11th of January. So we have in January of 2024 a clear crossing of the Rubicon, in my view, and everything that's happened since, if not before, is in effect complicity in ongoing genocide, or that's the evidence that needs to be assessed by a court. We don't have a finding to that effect, but I'm afraid that the evidence very strongly points to that. And as you say, it may take years, sadly, until we get an actual ruling from the International Court of Justice. But that doesn't mean we haven't crossed the point at which the risk that's been identified, the duty to prevent genocide, has been triggered a long time ago, and states should have been proactive. Now, why? It's all back down to politics. It's not law. So the law is clear, but states like the UK and the USA have made a decision to turn their backs on it and to keep sniping at the court, what the court has said so far, and to side with Israel, saying these are political determinations, not legal ones, and to seek to denigrate the work of the ICJ. I have to say this has a long-term damage to legal systems, and just as when a totalitarian state turns against its judiciary and turns against the rule of law, what is left then?
Yeah.
What is left? You are saying to people, peaceful means of resolving, which is what lawyers are trying to do for their clients and for states. Peaceful means of resolving disputes don't work because we're prepared to ignore the law and ignore the judgments. What signal is that sending to desperate Gazans, desperate West Bankers, desperate people on the wrong end of the law, where and of injustices, where the peaceful means to seek to resolve that and to address that through legal cases are falling short? Yeah. What is the message that they're sending? So long-term damage to peaceful means of resolving disputes and using the law to try and do that is huge. And so we're building into the future people who won't want to turn to the law, that will want to turn to violence. And are we going to be able to criticize that? Who is going to stand by and judge people who say, well, that didn't work, I'm now going to resort to violence. So, we need to sit back, and our politicians who are ignoring these judgments and what the law requires them to do need to do some deep thinking and reflecting. But nowhere is that apparently happening. Who knows? Maybe a Harris-Wolf regime post the November elections in the US may be capable of starting that thinking. But there are no particular signs of it in the current climate in America. But one has to hope that they will listen to the people like the more radical parts of the Democrat Party, Ilhan Omar, and people like that who are prepared to speak truth to power and who understand what I've just said, and are therefore able to try and have that dialogue internally with their own colleagues in the Democratic Party. But let's see.
We live in hope, and it's unfortunate that it's so politically driven. But just finally on the international law platform, and I guess another huge frustration, but it's one that you're very familiar with. And I'm interested in just getting your perspective on the ICC and the arrest warrants, which have not yet issued, which caused quite a stir back, I think, a number of months ago. And we're still sitting with nothing in front of us. But you have experience yourself in terms of issuing arrest warrants. So firstly, I'm wondering, can we talk about your efforts, and then maybe just get back to how you see things progressing through the ICC on the current outstanding arrest warrants, including one for Netanyahu himself?
Yes. So, briefly, in the early 2000s, there were a series of operations in both the West Bank and Gaza Strip, where there were increasing numbers of Palestinians being killed or injured. There's the whole settlement project, which is an international crime. And I was looking with lawyers about turning to universal jurisdiction. And this is all post in the UK, the Pinochet case. So, I was part of a movement of lawyers who saw an opportunity, and the lawyers who did the Pinochet case, we owe huge gratitude to them and to lots of international lawyers who come before me. Jeffrey Beinman was involved in the Pinochet case. So the lawyers who I was in contact with were saying, well, can we use universal jurisdiction? And this is before the International Criminal Court had really come into being. So it was a nascent International Criminal Court. Didn't fully come into being until around the time I started doing this work. But there was that discussion going on. And so I began to work with Palestinian lawyers on looking to see whether there was sufficient evidence to put before British courts, or any other courts for that matter, where there was jurisdiction. I won't go into the complexities. We've got a network of laws that enable cases to be brought. So universal jurisdiction is the sort of the consensus after the Second World War that we needed to create crimes which would be capable of being prosecuted by national courts, regardless of whether your own citizen was either a suspect or a victim. So some crimes are so heinous that they require this form of universal jurisdiction. And those are torture, whether committed in peacetime or war, and war crimes, and later on genocide, and then much more recently, since the 1990s, crimes against humanity. So we have those laws in place. They're not perfect, but in terms of war crimes, there was and is proper universal jurisdiction in the type I've just described under our Geneva Conventions Act 1957. And so that's the background. We saw some individual cases. We were collecting evidence, and we found that there was somebody travelling to the UK who was in the chain of command for cases which we had, 5 powerful cases. We produced that evidence to the Metropolitan Police in the summer of 2005 in relation to this suspect, Doron Almog, who was the head of Southern Command in Israel in the early 2000s. And they included a 1-ton bomb to kill one suspected terrorist, the kind of thing that Israel has been doing on a huge scale. And most recently, the bombing at the weekend, just gone, of the school in Gaza City. That kind of activity has been going on for decades, and they've been getting away with it. Anyway, he was in the chain of command for one of those. The British police said, no, this was all too complicated. In the time available, we can't investigate this. So there was then the opportunity of going to the most senior judge, district judge or magistrate in London, and putting the evidence before that judge called Workman. And we said, look, the police say it's too complicated. Here's the evidence. He's due to arrive on the following day. Here's the evidence we've got. He's been invited to give a talk in Solihull. Can you please grant us an arrest warrant? And that we had to go what I would call a strong prima facie case, not just a police officer arresting someone on the street. We had to pass that effectively the test to get an arrest warrant goes beyond the kind of police officer nabbing someone on evidence, beyond a reasonable suspicion. So we presented that evidence. In relation to one particular one, he'd given a television interview, effectively giving a televised confession of being involved in a war crime. And the judge saw that in court. We played the video. And we got the arrest warrant, and he travelled. Unfortunately, there was a decision made that for community affairs, somebody needed to warn the West Midlands Jewish community that there might be some incident. They didn't say with whom or with what, but that was sufficient to set a rumour going. Somebody approached the Israeli embassy. He was already landed in Heathrow Airport and was about to disembark and go through to be arrested at the gate because the police were there in Heathrow Airport to arrest him. And they allowed the military attaché who'd served with him in Gaza, in London, to go airside, completely forbidden, go on the aircraft and say, look, mate, the police are there to arrest you. You better just stay on and go back. So we were minutes away from having this guy arrested and I think prosecuted here in London for those crimes. Wow. And then something similar happened, which I won't bore you with the details of the then she had ceased to be when she travelled here. She had been the Foreign Secretary, Tzippi Livni, at the beginning of something called Operation Cast Lead in December 2008, where she also went on television and effectively admitted in public to participating in a war crime, and where we got another arrest warrant on that occasion. So those are kind of cases. And I've been involved as a result of that in many universal jurisdiction cases, which I'm afraid remain very much under the radar. The current ones I'm doing, I'm hoping someone's going to be prosecuted in this country, not to do with Israel, Palestine, but to do with major torture allegations. And that's been with the police for some time. And we were helping an NGO in Nepal, and we got a prosecution of someone who was acquitted for torture in Nepal. So that's the only public case, other than ones I've told you about, that I can speak about. But we continue to be involved working for victims of international crimes to try and get the police to do the right thing and for the Crown to prosecute these suspects. And I'm hopeful that we will see more prosecutions under universal jurisdiction, because the police are getting better at doing this work. In my experience, they're liaising with their colleagues in other countries where there have been more of these prosecutions. France, Netherlands, Germany have seen lots of universal jurisdiction prosecutions. We've seen a handful. Yeah. And we have many people travelling through the UK or who live here who are, I'm afraid, need to be prosecuted. They need to understand that they can't hide or run from justice.
Excellent. It's great to get the perspective and understanding of how matters work in that regard under universal jurisdiction. But why is it taking so long on an international footing under the ICC to issue the arrest warrants that they have?
I didn't answer.
Oh, no.
So, again, inexplicable. So the history of that, and again, it's difficult to keep it short, but I'll do my best. Mm-hmm. So Palestine sought to ratify the Rome Statute quite early on. So we're talking about almost 20 years ago now. Sorry, they didn't do that. Almost 10 years ago now. They sought to ratify the Rome Statute. So it's taken a decade to get to this point. That's the ridiculous thing. And it's just focused on the most recent events in Gaza, which again is wrong.
Yeah.
But where we got to here was, so as I said, the state of Palestine moved into a different gear in the 2010s, because it was recognised as a not fully fledged member state, but an observer state at the United Nations, and it's been recognised increasingly as having statehood, and including for the purposes of ratifying the Rome Statute. So what Palestine did when it was able to join the Rome Statute, it referred itself, and it's because it referred itself and the situation in its territory, putative territory, to the Chief Prosecutor's Office, that court has jurisdiction over events in the West Bank committed by Palestinians allegedly, and by Hamas militants in relation to what happened in Israel. So they referred themselves and brought the risk of their own nationals being prosecuted, the very live risk. So the 3 people against whom arrest warrant applications have been made, Israel has killed 2 of those people in the last few months. Since May, when the chief prosecutor said 3 Gazan leaders should be prosecuted, 2 of them have been assassinated by Israel. So Israel's not interested in international criminal justice, because its form of justice is to kill. That's the only way in which Israel understands how it's going to, address international justice. Anyway, going back to this quickly, the process has been very slow, and we only got, in May of 2024, almost a decade after Palestine sought to get international criminal justice enforced through the ICC, after a 2021 ruling just before the current chief prosecutor was in post, we have the possibility of there being these arrest warrants, or any arrest warrants. And although the Gaza war started in October, and though the prosecutor should have brought arrest warrants for settlements and for all the things that were happening way back, we finally get in May, after a panel mostly of British jurists, including eminent human rights lawyers that I know and respect, and the original legal advisor to the Israeli government in 1967, a really interesting man called Theodore Meron, was part of the advisory group that helped the chief prosecutor finally in May say, I'm going to apply to the chamber of the court for arrest warrants against Netanyahu and Gallant and the 3 Gazans I've just mentioned. So then what happened is, secretly initially, and I understand the British government were more or less told they had to do it secretly at this stage, the previous Conservative administration asked the court not to issue arrest warrants because of the Oslo Accords, in which there's a provision that says that the Palestinian Authority in the areas it controls in the West Bank and Gaza cannot exercise criminal jurisdiction over Israeli nationals. And the argument goes that you can't delegate to the ICC something you don't have. This is all a notion of property law, and not a notion of how one's national body, national state powers relate to the body or powers or jurisdiction of a supranational body like the International Criminal Court. It's literally a legal nonsense, in my view. But that's what the previous administration did. Happily, the Labour government didn't use that opportunity. So the deadline that they were given in August, they said, actually, you know what, we're leaving you to it. Unfortunately, they opened the door. The previous Tory administration opened the door to a process which is still ongoing. So something like 17 states did put in submissions, mostly against this Oslo Accords argument, and dozens of individuals and human rights organizations, and we're talking about dozens and dozens. So what's happened most recently, to catch you up to date, is that the court has said, and I don't think this has been very well publicized, so you probably haven't heard of this, the Office of the Prosecutor has until I think it's the 26th of August, with a 53-page limit, can respond to all of those submissions that have gone in to the court so far, to the chamber of the court. And so we have a process that's not going to end this month. At some point this autumn, the chamber of the court will look at everything, including this 53-page submission from the prosecutor's court office, and decide whether or not to issue these arrest warrants. And whether or not that last Gazan is alive by then, who knows? But we may get arrest warrants against the two Israeli suspects, Netanyahu and Gallant, in some time this autumn. But your guess is as good as mine as to the date of that. But every day that passes is a day too late for Gazans and for West Bankers, because the point of any criminal law system is to punish and deter. Yeah. We don't have punishment and we don't have deterrence at the moment. And the world, but particularly Palestinians under occupation, deserve the deterrent impact of criminal law.
Yeah, it's just incredibly frustrating that the submissions are just really a delay tactic. I mean, it's almost cruel in a way. Like, why can't they just let them get on with it and determine it, especially when we've seen so much noise about Labour withdrawing, what the Tory government's previous submissions. But anyway, as you say, your guess is as good as mine, and we'll wait and see and hope for some movement around those three cases, I suppose, that we just touched on, the two ICJ matters and also the ICC arrest warrants. Just moving on, Daniel, to your work in general, and I'm interested, it's a question we ask most of our guests, in terms of activism and the law. And I mean, your career you've covered so much in terms of vindicating the rights of people who've suffered at the hands of the state, your inquest work, your public inquiry work. We could spend all day talking about some of the cases that you've worked on. But what are your thoughts on activism and law, I suppose, working within the legal framework, but also pushing matters forward in terms of making real and meaningful societal change?
Yeah, well, I think when I am able to look back at, first of all, the courage of the client is never to be underestimated, because, facing the legal system to try and vindicate your rights, fighting on, sometimes in many cases is truly heroic. Just being able to have the courage and the sense of the burning sense, the need to get justice that's there with the clients. So you have to say the clients are key to this. Mm-hmm. And someone like Marcia Rigg, one of my clients who's become an amazing campaigner, that they have changed things, and we are their instruments of change. But where we're privileged enough to act for these courageous people, so I think that's a thing that I reflect on and I never want to forget. I think I can see examples of where our legal work I've done with clients has really changed things, and that drives me on and to the end of my career. I want to retire sometime soon, but currently the Grenfell cases are really important, and we'll keep on pushing for criminal justice again for those victims. And we'll see what happens, because the phase 2 of the inquiry is out in just a few weeks from now, in early September. But just one example, I think, back in the 1990s, next to where I went to school in West London, at Wormwood Scrubs Prison, there was a embedded violence against prisoners, especially those in the segregation unit, in the punishment wing of Wormwood Scrubs Prison. And the reforms that have come in as a result of uncovering the systemic violence in that prison in the 1990s means that prisoners across the country are far less likely to end up so neglected and so unable to prevent that happening in prisons in England and Wales. It's a combination of practical reforms and technology. Yeah. And I think technology, body-worn cameras, where they are actually used and held, are going to transform people's access to justice where they're available. And we've already seen that. Look at Manchester Airport, recently. But it was possible in the 1990s in Wormwood Scrubs Prison for prison officers to completely be unidentified. They had no lapels or signs, so the people couldn't always say who was consistently giving evidence against who was being violent to them. there was no body-worn cameras, no CCTV, but also prison officers in that prison could go to lunch and go to licensed premises on Wormwood Scrubs territory, have an alcoholic drink inside Wormwood Scrubs as an allowed event, and just go back on duty, fueled with alcohol. So we had many of our victims in Wormwood Scrubs Prison saying they smell alcohol on the breath of the prison officers as they beat them up. So reforms to prisons, these kind of, and I'm just giving that as an example. There have been many cases where clients, because they've come forward, got justice, have been able to change things so that it makes it less likely that people will be the victims of the same, or that if it were to happen, there's a greater likelihood of getting a just outcome. So, that's the type of work that I feel most proud of, where we can actually make a change. The horrendous side of it is where we failed, or where society has failed to stop, and that's the self-harm deaths in prisons. They're rife right at the moment. We have overcrowded prisons, regimes are unable to provide rehabilitation, and the mental health conditions of a really high proportion of prisoners that's not being properly addressed, and that leads to self-harm and death as a result of self-harm is alarming. So none of us are able to rest on our laurels when we're acting for bereaved families where that pattern isn't being broken. So it's really, so happy that some of these cases have led to real change and reduced the reoccurrence of these kind of abuses of power, but equally determined to try and find ways so that where there are repeat failures of the state, that somehow that changes. And it's for the next generation of lawyers to, pick up that mantle, work with these courageous clients and just make these breakthroughs. And I know there are so many people now in the legal profession that have that ability and passionate to bring that about. So that does leave me with, great hope that we will break some of these cycles.
And that leads me perfectly into the next question, which I guess you've touched on a little bit. Obviously, your work is incredibly challenging. There's no doubt about that, and difficult in many respects. As you represent, as you just said, bereaved families and working with very vulnerable clients too. I'm wondering, how do you manage those challenges in terms of your work? And also, what advice would you have for anybody who is willing to pick up the pace and take this work forward? As you said, there's still so much to do. What advice would you have for anyone listening that would like to follow in your footsteps?
Yeah, I think it's, work closely with clients, work out where there are legal issues that can be taken forward and rights vindicated, do strategic work with clients and with organizations like Inquest, with strategic organizations, network and think and liaise so that you are effective. And that will be, bring major benefits to the clients you're serving and help. We're part of a community, a really vibrant and thoughtful and passionate community. So don't neglect your work around, building those relationships, and building your knowledge, therefore, of what can be effective, so that you're doing the best work you can, rather than sort of groping in the dark on your own. Never feel isolated, because you're not. And I think that's important. And then, I've learned more than I appreciated about well-being. And it's something that we're now doing far better in our firm, and supporting people where it's really challenging work, and working on some of these cases it can be very challenging. So getting support, and we've had some help from some fantastic people who do that work now in a really thoughtful way. But I'll just give you one example, which is it's spreading the slime, we call it. So, when you're having tough times, and when you're, encountering real difficulties, talk to colleagues and spread the slime, and just releasing some of that emotion and talking it through and addressing it has been, I found, helpful even at this stage of my career.
I'm glad to hear that support is there. It's really important. Well, Daniel, you've been so generous with your time and you've clarified so many points for me. So I thank you for doing that and for taking us through some of your legal journey as well. I'm sure many of our listeners will be really interested to hear about that, and will continue to follow your sterling work. And I'd like to thank you for taking time to join me today.
Thank you so much.
Thanks everyone for joining me today. If you like the show, please remember to share and leave a review if you have a moment. And you can also check out our website, www.activistlawyer.com, where you will see some blog articles written by our guests and contributors, as well as some fabulous Activist Lawyer merchandise.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.